Coming up next on MCN 12, we go live to McAllen City Hall for an appeal of a disciplinary suspension affecting a McAllen police officer. This appeal is being heard by a third-party hearing examiner, as allowed by the rules of civil service, which apply to McAllen police and fire employees.
Ready to go?
Yeah, I just need to make a quick announcement here.
All right, sure.
Just a quick announcement, make sure that your cell phones are on vibrate or silent mode. Thanks.
Ready to go on the record?
Yes, sir.
All right, let's be on the record, and we'll call to order the De La Rosa case. From the documents I have before me, this is an indefinite suspension. Therefore, is the city ready to proceed?
The city's ready, sir.
And is the appellant ready to proceed?
The appellant's ready.
All right, do we have proposed joint exhibits?
I tendered some exhibits this morning to council. I have not heard back from them.
We did receive some exhibits concerning the investigations into the matters at hand. However, we do have objections to several of the exhibits.
All right, I take it then you have no objection to other exhibits?
Correct, that's correct.
All right. Why don't you identify those that you do not have an objection to, and let's get them in without objection.
And, sir, for the record, what we have done was that this big black binder here is the internal affairs binder.
All right.
That was produced and has been shared with council. For purposes of the hearing, we have organized, the city has organized these 3 notebooks, which consists of documents out of that IA file or all other materials that were produced, and it's just for ease of reference. And so that has been tendered to them as well. And I would, we intend to use these notebooks just because they're easier to reference than the IA folder itself. But it consists of the same sets of documents.
All right.
I'm confused on that. If we could clarify, if I'm correct, is he saying that the 3 binders given us today is the total of that binder, that large binder from the investigation?
I didn't get total. It's excerpts.
It's most of what's in that binder. There's a lot of things in the binder that are duplicated. They are not duplicated in the notebooks. And then there's some materials that were produced to them separately, which are things like activity logs and phone records that are in these binders that may or may not be in the IA file. But 98% of what's in these notebooks is in that binder.
You know,
And they're bait stamped so they can be identified as to what's in the binder.
there's an objection to the investigation, so you'll need to offer that as you go along.
We will.
It might be helpful if you could identify to us now which of the exhibits that you've got marked are out of the investigation.
I can do that, sir.
All right.
I can do that. Let me start with the exhibit notebook number 1.
All right.
And if at the front of that, there's a exhibit list that, for your convenience.
All right.
I want to point out that there's a reference in the header there to Texas Education Agency. That's my mistake. That's just from, this is a list that I picked up from another form. The AAA number at the top is correct. Obviously, this is not a TEA case. It's a third-party hearing examiner case out of the under 143. But in notebook number 1, sir, exhibit 1 is the charging letter, the civil service charging letter. And
No, I tell you what I'd like for you to do is point out which of these numbers are out of the investigative notebook, and then we'll go over the rest of them.
Okay.
There's certainly an objection to those, correct?
Correct.
All right.
All right. Well, number 1 is out of the notebook. You'll see in the bottom right-hand corner, tab 2. That's an indicator of what's out of the notebook. Number 2 is out of the notebook, the CLEAT appeal letter. Number 3 is a copy of the pertinent rules, regs, policies cited in the charging instrument. These are for your convenience.
Let me back up. Let's do it a different way. Let's take them one by one. Exhibit 1, any objection to the notice of indefinite suspension?
Yes, there are certain items in the notice of indefinite suspension which we object to.
All right. To the notice of appeal, any objection to that?
We have no objection
All
to
right.
that appeal.
All right. Exhibit number 3, the rules, regulations, policies, any objection?
To the extent each of them that are contained in this exhibit apply and are pertinent to what the charging letter has charged, then there's no objection.
All right, without objection, be admitted. 4, the crash report out of the notebook, correct?
Correct.
All right, any objection?
No objection.
All right, Exhibit 5, the written statement given pursuant to the order dated 1/6/2009. Any objection?
There is an objection to part of that written statement due to legal sufficiency. And most of these objections are due to a legal sufficiency that we'll be claiming that some of these charges, a few of these charges are outside the 180-day limit.
All right.
And part of that letter is that objection, goes to that objection.
You're talking about the July accident?
Yes.
All right.
Under this tab, there's actually, well, there's the order to give the statement as well behind it.
Any objection to the order?
To the order.
It'd be 5-1.
Only to the extent that it's improper and to the July incident.
All right. 6, the sworn testimony of De La Rosa in response to the contemplated disciplinary action, raised July 2008. Objection?
Same objection.
All right, same objection. All right, 7 is the return to work absentee form. Any objection to that?
No objection.
All right, without objection. Tab 8, Exhibit 8, prior disciplinary documents. Any objection to that?
To the extent it's discipline, we're okay with it. To the extent that it's not labeled or termed or deemed discipline, we object to those. And then some of them are very old.
Were they cited in the notice? Notice of disciplinary
Yeah,
action?
everything that's here was cited in the notice, yes.
All right. We'll address those objections as we go along. Notebook 2.
Is that where we are?
Yeah. So before we move, 2, 3, 7 are admitted. There's objection to 1, 4, 5, 6, 8. Is that what you got?
Yes.
All right. Notebook 2, polygraph examiner's report. Objection?
Yes.
All right. Number 2, Sergeant Arenas, IDC, what does that stand for?
Interdepartmental communication.
All right.
It's a
Any
report.
objection?
None.
All right. Be admitted. 1, Radica, fleet maintenance. Any objection?
No objection.
All right. Without objection. 4, Officer Barajas. 3, interdepartmental communications. Any objection to those?
Yes, I do have objection to it to the extent, and I'm sure that I've read at least all 3 of them, but there's a couple of them that refer to the July 3rd incident. To that extent, we would object. In fact, any of these that reflect on the July 3rd incident, we would like at least a standing objection until you can rule whether or not it's something you would like to look at.
I certainly understand that, and it seems to be the pattern of your objections that you're going to object to the use of the July 3rd incident because it's outside the 180 days. Is that correct? All right. All right. Costanza, same objection.
Yes.
All right. And Sergeant De La Rosa, objection to 1, 2, 3, 4, or 5.
Some of them are for December 3rd, so to the extent that I know the 16th, that number 2 is objectionable.
All right.
But as to the other 4, if they refer to the July 3rd incident, yes, we do object to them.
All right. We'll go through them. So out of that, the only one to which there is no objection is one that's the polygraph examiner's report, correct?
No, we objected to the polygraph.
Oh, did you?
Yes.
Okay.
There was no objection to number 2
Okay.
or number 3.
All right.
number, the second page of that.
There's a second page
It's
to
hearing
that, sir,
exam.
yeah.
Oh, I
There's
see.
a series
Okay.
of,
Maybe even a third. Rick, this book starts off with page 2. Is there a page 1? I don't mean to go outside the confines of the hearing examiners.
yeah, page 2 is notebook 2, so it starts with notebook 2.
It starts on page 2.
Yeah, the first notebook has the complete index at the front,
I see.
and then 2 and 3 just have the index for that notebook.
Okay.
All right, page 2, number 7, Garcia, objection.
None.
Hernandez, objection.
None.
Lorenzo Lara, objection.
There are some objections to part of his testimony dealing with the July 3rd incident.
All right. Torres, objection.
To the extent that some of it deals with the July 3rd incident, we do object.
All right, Exhibit 9 is admitted without objection. Next page, Trevino, objection.
I'm sorry, sir, Exhibit 9. Exhibit 8, wasn't it?
Let me
Exhibit 8.
check.
Exhibit 8, Joe Hernandez.
I marked it wrong. Trevino, objection.
None.
And De La Rosa, objection.
None.
All right, let's go over it, go back to the first page. Let me make sure about this. I was marking them differently, and I got some wrong. Arenas, no objection, correct?
Correct.
All right. Eradicate, no objection.
Correct.
All right. Rest of them on that page are objected to.
In part, yes, sir.
Yes.
Not totally.
Hernandez, no objection.
Number 8, no,
All right.
Number 7, you missed number 7. Garcia,
Garcia,
no objection.
no objection to Garcia. I mean, Hernandez, you do have an objection to, correct?
No, sir, I believe it's,
All right. Objection to Lar?
yes,
Objection to Torres?
yes.
All right. Trevino and De La Rosa, no objection?
None.
All right. All right, notebook 3, rotation schedules, objection?
None.
All right. KRONOS reports, objection?
I think I've looked at them, but to the extent that they apply to the July 3rd incident, I do, but I'm not sure that they do.
All right.
They are either the 12/3 incident or the July 3rd or the missed work days
The
of
February thing,
February 7 and 8.
yeah, just to the extent that the July 3rd, the rest of them are, not objection.
All right. Phone logs, objection.
No, sir.
All right. Unit log listings,
As obviously to that number 1.
yeah, number 1. So there would be no objection to 4.2.
That's correct.
All right. Incident report, no objection.
Subject to his verification of the report, but there's no objection generally to that report.
All right, 1, 3, 4.2, and 5.1 are admitted. Are there further proposed joint exhibits?
I think there's another page.
I have
Oh.
behind that notebook, the set of notice letters and orders, the administrative
All right.
notice letters and orders.
Any objection to any of those?
We overall and generally objecting to any part of the orders dealing with the July 3rd incident.
Maybe-
And some of them, and I think, I could be, I think I'm correct on this, most of these are lumped together into the same letters. They're repeated over and over. So to the extent that any of them deal with facts or circumstances concerning the July 3rd incident, yes, we do object to them.
So the order on January 6, 2009, as set forth in the notice of indefinite suspension, that was an order that encompassed both the December incident and the July accident.
That's what I'm, yes, it does.
Yeah, let me simplify this
All right.
for everybody, I think. And I don't have a problem with a running objection to legal limitations issues as to the July incident. I think that will make this go a little smoother. In these orders, the July incident was resolved through a reprimand, which is number 6 here of the at the back of this third notebook, which
All
are
right.
the notices. So number 6 is a 4109 reprimand reference July 3rd crash incident. It is correct that during the investigative component of this, that both of those were noticed as being the subject of investigation and the subject of the statements. Okay, that is correct. In the end, because of the 180-day rule, the July 3rd incident was resolved through a reprimand, which is tab number 6.
All right.
So you're going to see in the, I think that you're going to see in the administrative orders and documents that, you know, those incidents are referenced in the document. So if he wants to have a running objection to the treatment of the July incident, I don't have a problem with that as far as legal preclusion or how the chief used that. The chief will explain how he dealt with that issue and how he dealt with the limitations issue.
All right, I don't want to get into it now. I haven't heard opening statements. I may have some questions after opening statements about the use of the July incident, but for right now, I'm going to let that go. All right?
Very well.
Certainly, you would not waive any objection that you have to the use of the July accident. You certainly wouldn't waive that objection even if they're admitted. I mean, somebody's going to have to decide, and it's going to be me, as to the appropriateness of using the July accident in any way in this case. And so be it the 180-day exclusionary rule, not exclusionary rule, the 180-day rule, or the fact that it's already been dealt with. And so even if they get in, I suspect they'll get in conditionally. You're certainly not going to waive that objection, because at some point I'm going to have to rule on that.
And that's the purpose behind my objections. I hope I had to preserve those for the record, but I certainly understand what you stated, and we'll go forward from there with that, with this understanding that we all have on it.
Very good.
Yeah, I would not take the position that just because we talk about it in the evidentiary component of this, that somehow they waive this 180-day rule. That's not a position that we would
No, I
take.
know that wasn't your position, but I need to put it on the record anyway.
That's, understand.
All right, is the rule going to be invoked in this case?
Yes, it is.
All right, everybody who knows yourselves to be witnesses, please stand and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Just have a seat. I need to give you some instructions. The rule's been invoked in this case. Invoking the rule means two things. The first thing it means is that those witnesses who are not testifying must remain outside the hearing room during the testimony of other witnesses. That's called sequestering the witnesses. There are two exceptions to this portion of the rule. The first exception, of course, is the appellant. Mr. De La Rosa, you're certainly entitled to remain inside the hearing room during the entire course of the proceedings. There is a second exception to this portion of the rule. That exception is this: each party is entitled to select an individual who will be a witness to be their technical advisor in the case. A person so selected is exempted from the portion of the rule that requires them to remain outside the hearing room during the testimony of the other witnesses. City, you want to select the chief?
The chief.
All right. Chief's name?
My name is Victor Rodriguez. Rodriguez.
Spell it again, please.
Yes, sir. Victor Rodriguez, Rodriguez.
Appellant, do you wish to select a technical advisor?
We just have it, Sergeant De La Rosa, that's all.
All right. The second portion of the rule is this. As I've told you, do not discuss your testimony or this case with anyone except counsel if you choose to do so. Just to make an example of you, Mr. De La Rosa, if you want to talk to your counsel, either of your counsel, about your case or your testimony, you're certainly entitled to do so, and that applies to every other witness. Do not do so in presence of others, though. I would caution the parties at this point to pay particular attention to this instruction. In these cases before, I've had to strike testimony. In these cases before, I've had to disqualify witnesses. And I would not hesitate to do that in this case if I thought it was necessary to address a rules violation. I've learned to do that over the years because of confusion about the rule, and so I always take the opportunity at the time that the rule's invoked to stress to everybody, please don't put me in the position of having to strike your testimony or to disqualify you as a witness. Just a word to counsel. I consider the rule to have been invoked as to every witness as of this moment in time. If you have witnesses who are not here and you need time to call them and explain the rule and how I intend to go about trying to enforce it, I will certainly give you that time. Is there any question about the rule?
Mr. Hearing Examiner, we do have one thing that I think needs to be very clear from you, is that this hearing is being broadcast on government TV,
All right.
and that all witnesses need to be made aware that they cannot watch it or something, however you wish to handle that, because it is public TV.
Yes, I do need to handle that, and I did not know that, but I appreciate you pointing that out to me. As I understand it, have you just heard the counsel for the appellant state? This hearing, is it on live or delay?
Live.
It's on live. This hearing is on live public TV. So that means if you're a witness or even in the audience, that you are susceptible to being on TV. So if you have a problem with that, don't be in the hearing room. All right? Anything else?
Nothing from the appellant.
One other matter, just to backtrack a little bit. We didn't go over this IA notebook as far as the stipulations on the exhibits. That notebook is being offered as well as the complete IA file that we got from the department.
Let me get you to hold it for right now.
Okay.
I think when we get to the evidentiary portion of the hearing, that would be the appropriate time to offer that.
Very well.
I take it you're not offering it for the truth of the matter stated therein, but you're offering it solely as a report that was relied on by the chief in making his decision.
That's correct.
All right. All right. Anything else of a preliminary nature before we go to opening statements?
We'd like an opportunity to have the chief make sure that reference your orders on the watching of the TV, that we get word out administratively to our witnesses about that.
Let's be in recess for 5 minutes, 10 minutes. Sure, go ahead.
That's what's on the list.
Nothing more. I thought you had said 90%.
Yeah, well, then I produced a separate set of documents, which were not in there. I can show you here. One of them is this, is here, is Hernandez, is, this. Okay. This. This was part of his, yeah, the third page, it's 3 pages of the reconstruction.
The other two pages, or something you're using.
Well, they were already in there.
Oh, already.
They were already in there. They were in that notebook. During the course of talking to him, I realized I had this page loose, and I was like, well, where does this go? And he goes, well, that goes here. And when we checked the notebook, it was not in there. So you got that, and you got the photos and the diagrams. That's
That's the extra stuff you're looking
that's the extra stuff. Okay. And then, I think, I may have run some Kronos reports, just, really they're just for reference more than anything, because people don't remember when they were. So just our records of when people were.
Kind of figures.
Yeah, I mean, it's just in the course of.
Only really relates to preliminary things.
Right.
Yeah, okay. Yeah, probably so. Yeah. Michael? There are a number of factual allegations on page 4 of the notice, and I haven't read more than 10 of them, but it looks like to me there may be something we could stipulate too. Would you take a look at those and see? I'm talking about where it starts on page 4 of the notice of indefinite suspension, and I'm talking about the last sentence on that. We're not on the record. The last sentence on that page, Sergeant De La Rosa was on duty on December 3rd, 2008. That's the kind of fact that probably is not going to be objected to. Next page. Would you just take some time and go over those and see if it would be fruitful for us to go through and see what can be stipulated to and what cannot be? I hate to put on testimony about things that are not in dispute.
What page were you referencing, sir?
Page 4. At the very bottom of the page it starts, and there's a series of facts over the next
those bullets.
Yeah.
us back, I think we're ready on all the bullets.
All right. Are there enough there that are uncontested that it would be worthwhile to go over them?
I suppose so.
All right. What I propose to do is go page by page and have you read the ones that are contested.
Contested?
Contested,
Okay.
yes.
Well, we can start on, I can do that.
All right, very good. On page 4, there's only one allegation of fact. That's not contested, is it?
No.
All right. On page 5, yeah, excuse me. We are back on the record. Yeah, on page 4, that allegation of fact on page 4 is not contested. Is that correct?
That's correct.
All right. On page 5, are there allegations of fact on page 5 that are contested?
Yes.
All right. Could you identify those for me?
Would you like me to just read them?
Yeah.
Okay.
Just tell me where they are generally before you start reading.
Okay, the very first one.
All right.
Sergeant De La Rosa was Officer Castaneda's supervisor on December 3rd, 2008.
Contested.
Contested. Number 2, Sergeant De La Rosa pre-arranged to meet Officer Castaneda at Luby's Cafeteria with the address. That's contested.
All right. Contested.
Mr. Arbitrator, there apparently are some witnesses in the room.
Are there witnesses out in the audience?
Yes, sir.
Were those witnesses that were not here for the,
No, I think they're all
All right.
witnesses that,
if you are a witness, the rule would preclude you from being inside the hearing room. And I'm going to have to rely on counsel to help me.
Enforce that.
Enforce
Okay.
that. I don't know whether they are or not.
I just happened to notice that 5 or 6 of them were in here, so I just wanted to make sure.
Well, I appreciate you pointing that out. Please watch to make sure that none of your witnesses are inside the hearing room, both sides. All right, please continue.
Number 6, Sergeant De La Rosa immediately surmised that Officer Castaneda's unit had been struck while it was unattended and asked for the location of her previously assigned calls for service.
Contested.
Contested. Next would be the 4th one from the bottom. On July 3rd, 2008, Officer Castaneda reported to Sergeant De La Rosa that she had been involved in an accident. Do I need to read on? through
No,
the
you
whole-
don't.
Okay.
Contested.
Contested. And then the next item is also contested.
Contested.
And then the next item below that, Sergeant De La Rosa took no action, no
Contested.
reporting, contested. We have no problem with the last one.
All right. Page 6.
may I get a clarification? So if it's not contested, does it mean it's uncontested?
Yeah, it means it's uncontested. It also means that you don't need to present evidence on that point. If you do present evidence, I'll hear it. But if the evidence you present is contrary to the stipulation or the fact that it's not contested, I'm going to go by what's not contested.
And again, we have that overarching objection on the 180-day rule to the July
Absolutely.
3rd incident.
So what will probably happen, or what will happen, is I will admit that conditioned upon a finding that that incident is appropriate, either because considering the 180-day rule or whatever other objection you have to it.
Yes, sir. Now, on page 6, the 4th bullet, Sergeant De La Rosa does not recall.
Contested.
Contested. And then dropping down to the next set of bullets, the fourth bullet there, Sergeant De La Rosa claims seeing
Contested.
the damage. That's contested. The next bullet is also contested.
All right, contested.
And then the next to last one, Sergeant indicates in his CR3 crash report.
Contested.
Report complete, yes. Page 7. The fourth bullet that begins on the date of this event and while at Libby's
Contested.
cafeteria. The next one, Officer Castaneda further states that.
Contested.
And then the last 5 bullets are contested.
All right. Starting with Officer Costanza states, correct?
Yes, sir. On page 8, the first bullet is contested with fleet personnel Juan
Contested.
Arratia. The third and fourth, well, I'm sorry, third, fourth, fifth, sixth, seventh, eighth, actually the rest of that page, I'm sorry.
All right.
The rest of that page is contested. The only one that we don't contest is that second bullet.
All right.
So the one starting Officer Castaneda reported, that's the
Yes.
contested and all the way down?
Yes.
All right, is there anything else of a preliminary nature before we go to opening statements? City opening statement.
Yes, sir. Sir, the city's, this is an indefinite suspension, and it has to do with the failure to comply with rules, regulations, policies relating to reporting procedures, honesty and candor in the reporting procedures, compliance with practices on reporting procedures, particularly with regard to the use of patrol vehicles. The primary incident in the case is going to be a December 3rd, 2008 incident involving the patrol unit of then Officer Karina Castaneda and its handling by Sergeant De La Rosa on that evening. The allegations are that Sergeant De La Rosa created and falsified a crash report, that he failed to follow procedure and protocol in the handling of that accident and attempted to either minimize or whitewash that accident, that crash completely. During the course of that investigation, the evidence is going to show that another incident came to light, which had actually involving the same officer, Karina Castaneda, that had occurred back in July of 2008. The actual, while that provides the backdrop of the charges, I would point out that the case turns on the and this is why the exhibit notebook is organized the way it is, that the first incident involves, of course, a December 3rd incident, as to which there is no 180-day rule. But the next exhibit is the statement given under an order to give statement. That's our exhibit number 5 in notebook 1, in which we will demonstrate to the hearing examiner that Sergeant De La Rosa, by omission and also, by affirmative statement, misrepresented facts in response to this order to give statement, under which he was a duty to be candid, forthright, honest, and that he in the preparation of this statement, misled the department about the facts relating to not only the December 3rd incident and his handling of that incident, but as well in connection with what had in fact happened with respect to the July incident. Our Exhibit 2 therefore consists of his statement of January 7th of '09 and the order to give statement, which does reference both the July and the December incident. The evidence will show that in the end, the July incident was resolved through a reprimand, which is also an exhibit, and that was resolved because of the limitation under the 180 days. The third exhibit that involves the misconduct here are, again, similar misrepresentations, deceptions, omissions that were made to the chief in connection with the sworn testimony of Sergeant De La Rosa on January 16th of 2009. That is our Exhibit 6. And again, in connection with Sergeant De La Rosa's conduct and performance of duties on the January 16, '09, there is no 180-day issue or rule. We will demonstrate what the misrepresentations and material omissions were as to that statement. And then finally, the final incident involves, under our first notebook, Exhibit 7, the absentee work form, which involves 2 days in which Sergeant De La Rosa was supposed to be at work, in which he did not show up for work. He basically modified his own schedule on this, did not get the appropriate prior approvals and leaves. And so that's a separate set of incidents that is charged. There are no 180-day limitations as to that incident. But it's, aside from being absent without leave on those days, it also illustrates the practice of Sergeant De La Rosa of basically interpreting the rules to fit his own needs. We have charged in the charging letter a set of prior discipline that the chief has included in the charging letter. The evidence will show, and this material is under Exhibit 8, prior incidents where the chief has dealt with similar concerns involving Sergeant De La Rosa, where information is either half true or partially true, or there are omissions from information where he has a duty to provide that full and honest and candid information. And the particular items that are listed in the prior discipline component of the charging letter, we will go through with the chief. Because the case involves essentially misrepresentation and deception involving report writing duties and obligations in connection with the provision of law enforcement duties within the city. The chief did, at one point, order a polygraph examination of this officer to really explore and to use every available tool that he had at his disposal to try to pin down whether this were issues of error or mistaken judgment, or whether they were intentional efforts to deceive or whitewash or cover up incidents involving the performance of, essentially the performance of duties. So the case is going to start out on the city side with the December 3rd incident. There's no limitations issues as to that incident. And to the extent that there's any discussion about the July 3rd incident, the evidence will demonstrate that came up because that incident was unknown to the department at the time that the department became aware of it in December. And so the discussion will be limited to that. The material misconduct for purposes of this case is going to be misconduct in connection with responses to orders to give statement, orders to provide information, not only about the December 3rd incident, but also about, what in fact had happened on the July incident. So the July incident is not in and of itself was resolved through a reprimand, which is in one of the administrative documents that's in the notebooks. The chief will discuss, the handling of that. But the misconduct at issue, really for purposes of this hearing, has to do with the difficulty that the department had, that departmental management has, that Chief Rodriguez had, in really getting down to the facts of what really happened, not only in December 3rd, but as it turned out, what had happened previously, because even the July 3rd incident had not been properly reported, had not been properly documented, was basically hidden and whitewashed. And it's in connection with efforts to get that information during the investigative stage that the misconduct is focused. So that is going to be the thrust of the department's case against Mr. De La Rosa.
Thank you. Let me see if I've got it. The July incident, in and of itself, is not a basis for the disciplinary action that was taken. It is only a basis to the extent that there was untruthfulness in answering questions about that incident. Do I have it right?
That's correct,
All
sir.
right. Very good. You want to make an opening statement, Pallant, or defer?
No, we'll go ahead and make the opening
Please go
statement.
ahead.
Thank you very much. And we will, since the part of our case is thrust on the July 3rd incident, we will start off there. The city basically has attempted to go in the back door where they could not go in the front door. In fact, they knew about the possible improprieties of a July 3rd incident in December, well within the 180-day limit, and they didn't take any action on that until it was well without the 180-day limit. On January 6th, they order Sergeant De La Rosa to answer to questions the next day, January 7th. That's 189 days out. So therein, the city is attempting to, or the information they get from that is tainted because they have no way of issuing discipline on that particular incident. Well, they could have, but they didn't. They didn't start it within that period of time. So therefore, we are arguing that Sergeant De La Rosa, in receiving his written reprimand, which, by the way, under the current contract with the city of McAllen, reprimands are discipline, whereas normally in Texas they are not disciplined. It is discipline, and they did discipline thoroughly that incident of July 3rd on April 1st, or it's in the documents, but the written reprimand, with a written reprimand. So, yes, we do contest it, and we will contest it through legal sufficiency that the city has tried to discipline him twice with a reprimand, number one, and then an indefinite suspension. But on top of all of that, they're disciplining him for something they cannot do, and even under state law, because of the 180-day expiration. The 180-day rule is in 143. Facts will show, evidence will show that this is, 143 governs this case, that the city is bound by 143. They are also, to some extent, bound by their contract, which even goes further in allowing a reprimand to be disciplined. So we do contest that charge as being grounds for determination in a indefinite suspension that we're here on today. In this case, we're ultimately going to ask you to put Sergeant De La Rosa back to work, and we believe that the issues here, are the facts legally sufficient to sustain one or more of the allegations? I think that the facts will clearly show that the past practice of this department, that he, and I'm going to jump around a little bit, but the AWOL situation on February 7th and February 8th of this year, the past practice of this department allows exactly to occur what did occur. That at least one witness for the city seems to remember later on certain information, whereas when questioned about it, he had made comments to another sergeant that he didn't remember anything about the facts of the case. So in that regard, we believe that the evidence will show that the city's case is not near as strong on the AWOL situation, simply because officers routinely, even if the city can show a policy where they have to sign up for vacation in advance, routinely sign up after the event, and it is all okay with the city. It has passed muster with the city in the past, and no discipline has ever come of it. We believe the city has built really a mountain out of a molehill just because of a bias or animosity that this chief has toward Sergeant De La Rosa. We'll get into those facts during the case. The December 3rd incident, and whether you call it an accident or an incident, we at that time on December 3rd, it turned out that the best case scenario, or the best probability, if you will, as Sergeant De La Rosa put in his report, the city acknowledges his best conclusion on that day, December 3rd, 2008, was that the vehicle that was damaged, according to the officer who reported it to him, had been struck while the vehicle was unattended. Now, can you ever be sure? Can you be absolutely sure that that happened? You can only go by what people tell you. You can only go by how the officer reports it to you. And that's what Sergeant De La Rosa did that night. Sergeant De La Rosa, it will be shown, has investigated many of these fleet accidents, whether it's motor vehicle to motor vehicle or motor vehicle to fixed object. He's investigated many of them, and he knows how to do it, and the chief knows he knows how to do it. And he knows that the investigation that Sergeant De La Rosa started, now I use that word very clearly, started but didn't finish, was well in the process of being done in accordance with the procedures of this department. Within 6 or 7 days of the beginning of this, starting of this report, the facts will show the report procedure, the report responsibility were taken from Sergeant De La Rosa, and he did not and was not able to finish it as another officer did. So the chief will, or the city will, try to convince you that the facts show that there was some conspiracy, when in effect, to lighten the load or to make Officer Castaneda not receive punishment. But in effect, the facts show exactly what the video from Luby show, that the first time he noticed Sergeant De La Rosa noticed the damage was when they came out of Luby's, not before, that he contacted his immediate supervisor immediately, and subsequently this accident was reported in a proper manner. We intend on this letter of suspension that I've objected to, that was just gone over here to some degree, shows exactly the bias or animus, if you will, toward it Sergeant De La Rosa, Chief Rodriguez has, in that he actually says he was insubordinate to the chief when he goes to the Loudermill hearing, or refuses to go to the Loudermill hearing, but when he does go to the Loudermill hearing, he doesn't answer his questions. Obviously, the chief has misinterpreted what a Loudermill hearing is. It's an opportunity for the officer to talk if he wants to, but if he doesn't want to, he doesn't have to, And if he doesn't talk to the chief or present argument, basically what it amounts to, then the chief turns around and says, well, you're not cooperating in this investigation. Well, that's not part of the investigation. The Loudermill is not. It's a last chance for the officer to convince the chief not to take certain disciplinary actions. Well, in the past, as you will hear the testimony, the only thing that occurs when Eddie De La Rosa and maybe some other officers, but more importantly here, goes to a Loudermill hearing with the chief, whatever he says is used against him, turned around and says, you're lying. And that's exactly what happens at the chief's Loudermill hearings. And so Sergeant De La Rosa took the high road, if you will, and says, I'm not going to go to your Loudermill hearings. Do as you wish. The chief's letter of indefinite suspension is also objectionable to the extent he puts in settlement language that was conversations that were had between Sergeant De La Rosa, his then attorney representing him in that instance, Mr. Curtis, and twists those conversations around to reflect not what was said, but only to appear to be more demeaning and damaging toward Eddie De La Rosa. To the degree that I believe it's even more objectionable is that settlement discussions do not belong in any letter of suspension, much less a letter of indefinite suspension. The chief puts in his letter that, and we've gone over a little bit, but there's plenty of letters of counseling, other undisciplinary type situations, but they're multi-years old. The last suspension Sergeant De La Rosa had was for a one-day suspension on an accident back in the hurricane last year. Before that, it was 5 years ago, a 6-day suspension. But aside from those two, that was it, other than letters of counseling and maybe a reprimand here and there. The chief fails to recognize the good part about Eddie De La Rosa. We have information and exhibits to show that even as late as this year and the end of last year, well, at the end of last year, Chief Rodriguez himself was commending Eddie on the good job he's doing. So, but the chief failed to put that in his letter of suspension as mitigating factors. We believe those are mitigating factors with his limited disciplinary issues in the past, that the discipline here was excessive. To go a little bit further, do the facts support or sustain any one or more of the allegations? If so, what allegations have been sustained? And ultimately, was the discipline issued herein excessive based on the facts found to be sustained and taking into consideration the mitigating factors? We don't believe the chief did take in mitigating factors. We would believe the discipline was excessive. The last thing, Mr. Hearing, I'm going to have here is what we believe to be inappropriate conduct by the city and its agents concerning one of the exhibits we objected to, and that was a deposition held at 6:30 p.m. on last Friday, of Karina Castaneda. We object to that for the mere fact that they used this process, this hearing process, to issue subpoena signed by you to have her come in and do a deposition without notifying us that we could attend and have the opportunity to cross-examine. Mr. Navarro did the deposition at the insistence, I'm sure, of the chief. But in that regard, without giving us notice, we believe that not only should that exhibit that they've tendered for your perusal should be stricken, but her entire testimony should be stricken, and she should not be able to be used as a witness. We feel like it's egregious conduct. We were down here, Mr. Navarro was in contact with Mr. Curtis all week long. We were down here on Tuesday preparing for this hearing, and have always been available, or at least to try to be available for things such as this in the past. We think that under the rules of procedure, that such conduct would require the restriction of her testimony, or the total restriction of her testimony in its entirety. We believe that the ruse for the subpoena signed by you to get her into the depot was unconscionable, and we ask for that remedy.
All right, thank you very much. I have just a couple of questions for each of you. I'll start with the city. In the opening statement, the appellant contends that the reprimand was disciplinary action according to the collective bargaining contract between the city and the police association. I need to get your, I need to get your position on that.
Have you read it? Is it? Okay. We're looking at that contract. This is the first I hear of that. Obviously, under 143, it's not discipline.
That's right.
And so unless there's contract language that would convert it, Mr. Ozuna, who's an attorney with my office, is looking at it, and I think is saying that it does not, we disagree with that position.
We disagree with counsel's position unless he is referring to a section that I have not read. It appears that two of the articles in the current CBA, which applied at the time the disciplinary action was issued to Sergeant De La Rosa, would be Article 24 and Article 25. Article 24 is entitled Disciplinary Suspensions. It does not mention reprimands, and it states that disciplinary suspensions and appeals shall be governed by the current applicable section of Chapter 143 Texas Local Government Code. So that article evinces no intent to modify Texas civil service law with regard to what constitutes a disciplinary action. Of course, Chapter 143 defines disciplinary actions to be suspensions, demotions, termination, and uncompensated duty, which is not an issue here. And nothing in subchapter D of Chapter 143 mentions reprimands. They are traditionally not treated as disciplinary actions, as counsel acknowledged. The other article is Article 25, which has to do with personnel files and disciplinary records. Again, there is nothing in this article that indicates that counseling letters are to be treated as disciplinary actions. They have a special handling under this article, which indicates that they can be purged like disciplinary actions after a certain amount of misconduct-free service with the department. Again, that provision doesn't apply here, and nor does it evince any kind of intent to modify the Texas Civil Service law to bring reprimands or counseling letters under the umbrella of disciplinary actions. There is a distinction in this article, as well as Article 24, for the two types of actions. That is the current state of the law under Chapter 143. There is no other article that I have seen in this contract that would indicate that there was some intent to bring reprimands or counseling letters under the umbrella of disciplinary actions and treat them as disciplinary actions for the purpose of the 180-day rule or any other purpose.
We don't need to get into that now. We can get into it when there's testimony offered about that and there's an objection. So we'll just defer until we get to that point in the hearing. The other thing that I wanted to ask you about is the representation of the appellant in their opening statement was that settlement discussion, and I haven't read the notice of disciplinary action or notice of indefinite suspension, but their representation was that that settlement discussions were included in the notice of disciplinary action. I need to get your position with regard to that. And they also take the position that that's entirely inappropriate. I need to get your position on that.
There was a point in time when there was some I guess, negotiations between Mr. Curtis and the chief and regarding Mr. De La Rosa's investigation and the potential discipline. The documents that I have, and it's my understanding that issue had to do with concerns about the 180-day period continuing to run, and that the discussions were included in the letter to make it clear that the 180-day period was of concern. There was an abatement at one point by the chief to not do anything further pending.
I'm not following it. Could you direct me to that part of the letter? Let me get it in front of me.
I think page 19, just here an example.
Could
And
you give me a moment? Let me
yes.
read it. On page 19. Start reading it for me. Which part are we talking
February 24, 2009, it starts the contact by, actually, in the page before 18, the chief says, the following have acted to delay an earlier decision in these matters. And then he explains on February 24, Mr. Curtis contacted, the chief saying, I was contacted by Mr. Curtis, Councilor De La Rosa. I can read the whole thing if you want into the
Just
record.
begins
I'll
at the beginning of the
paraphrase it.
page.
Let me just read.
Okay.
You're talking about the first two paragraphs?
Yes, and I believe up there.
Yeah, I think it
Probably
pretty much goes through the whole page here, through the three-quarters of the way down.
Yeah,
Through the italics.
yeah.
Let me ask you this. Do you suggest that I attach any weight in this case to the references on page 19 to discussions about a proposal to resolve the matter?
I think the weight to be attached there will come from, in terms of just, what these discussions, the impact they had on the chief, his attitude towards the sergeant's acknowledgement of the allegations, his own beliefs about what he wanted to do or not do in the case, and the impact they had on the chief's ultimate determination or ultimate decision. I mean,
Let me ask you a different way. These facts, should I give any weight to them in deciding whether or not the appellant engaged in the misconduct set forth in the notice?
I think that issue, sir, goes to the credibility that you will give to the chief's testimony about how he reached his decision on this and whether it's justified. So the answer, I think, has to be yes, because I know that the chief did
Well, then we would
consider
renew our
this.
objection on that.
All right, object when we'll get to that part of the evidentiary hearing, so object. I'll rule on it then. One question for the appellant. The deposition of Costanza. If I'm writing my decision and I wanted to rule for you, and I'm not saying I do, I want you to understand that. But let's say I agreed with your argument. Let's just say, for the purposes, assuming that fact to be true, that I agreed with your argument. What rule, regulation, procedure would I find that he violated by doing that? By taking Costanza's deposition on Friday?
When you say he violated?
I may be, correct me if I'm wrong, but I thought an argument you made in opening statement was that the city took Costanza's deposition last Friday.
I
Is
did,
that-
and
is
I
that
just
correct?
want, that's correct. And are you saying the chief violated, or?
Either one. In other words, if I bought your argument, that was incorrect. What rule, regulation, procedure, statute would I say they violated by doing that?
I would say that the rules of procedure, on any time you take a deposition in preparation for a hearing or preparation for court, which obviously the city took that position when they took a deposition, has to be noticed to the other party and given the other party enough time to attend, or opportunity to attend, and that if they don't, then that is grounds enough to dismiss or to retract or rescind the use of that document, that deposition, in any hearing afterwards. Now, in addition to that, going back to strict 143, I think it's 052 or 053, but I think it's 052, the chief is restricted to his letter of indefinite suspension and nothing more. Anything obtained afterwards is a modification of that letter, and that's inappropriate under 143. So there would be a strict statutory law, statutory violation of 143 by introducing this evidence after the fact, even further outside the 180 days. Even on the December 3rd case, but more importantly, past the July 3rd case. So I believe that would be by accepting that testimony on Friday, in the confines of what I believed were going on with the deposition, that we should have been given that opportunity to attend and cross-examine. And we weren't given that, and I think the civil rules of procedure would demand that be stricken, or not used. It hadn't been admitted yet, hadn't been admitted yet, but not used, not admissible. But even more importantly, under 143, I believe it would be an amendment of the letter of indefinite suspension that was issued May 29th this year, and therefore would not be able to be used. It was something that the chief did not consider at the time, and up to even before the time that he suspended him indefinitely. But more importantly, at the time he had suspended him indefinitely, it was information or investigation that he did not have.
All right, we'll get into it further when the testimony is offered. I just have one question, and that is this. As you know, some collective bargaining contracts provide that the rules of evidence will apply. And I'm not aware of any that say that the rules of civil procedure will apply. Let me just ask you, what does the contract between these parties say with regard to whether or not rules of civil procedure apply, rules of evidence apply?
I would have to look directly. I can't answer your question at the contract. I know that there are many that say they do apply, and as you said, some that say they don't, but I always go by at least the general concept that the hearing examiner is able to apply the rules of and decorum of the proceedings as needed, whether the rules of evidence or rules of civil procedure are followed to the T or not. I would have to look at the contract to answer that more directly, because it would control if it's in there.
Well, look at that. See what it says. If it doesn't say anything about it, then you're going to need to answer the question for me. What rule would I say they violated by doing that?
Well, as I said in my argument, 143, I think it's 052, I'll get the subsection, but the chief is confined to his original letter.
There's no doubt about that. I mean, if they're using it to expand the charges in the letter, they can't do that. But I'm anticipating they will say they were seeking to find out the facts when they got to the hearing. So we'll get into that later on, all right?
Okay.
I take it you're not trying to expand the charges Well, let me just ask you, let me not assume it.
We're not expanding the
All right,
charges.
okay.
We have factual evidence.
Let's take 10 minutes.